Hello, I'm Deb Bussinger with the Leesburg Public Library. We are so excited to host Judith Ann Scourfield-McLauchlan today. This program is a partnership between Florida Humanities and the Leesburg Public Library. Funding for this program was provided by Florida Humanities and sponsored in part by the State of Florida, Department of State, Division of Arts and Culture, and the Florida Council on Arts and Culture. I'd like to tell you a little bit about Dr. Judith Ann Scourfield-McLauchlan. She is an associate professor of political science and founding director of the Center for Civic Engagement at the University of South Florida, St. Petersburg, where she teaches courses in American government and public law. McLauchlan was awarded the American Political Science Association and Pi Sigma Alpha's Certificate for Outstanding Teaching in Political Science, USF's Chancellor's Award for Excellence in Teaching, the USF Outstanding Faculty Award, and was named one of the top 25 women professors in Florida. Her book, Congressional Participation as Amicus Curiae Before the US Supreme Court, explores how members of Congress attempt to influence Supreme Court decision-making in specific cases. In addition to her scholarly activities, Professor McLauchlan has extensive experience in American government and politics. McLauchlan worked at the US Supreme Court, the US Senate Judiciary Committee, the US Department of Justice, and the White House. A veteran of several presidential campaigns, she has managed statewide operations across the US from Portland, Maine to Portland, Oregon. In 2014, she was a candidate for Florida State District 22. Please welcome Dr. Judith Scourfield-McLauchlan.
Thank you so much. It is definitely a pleasure to be here. And I'm looking forward to speaking with you about the Supreme Court of the United States. I am a former member of the Office of the Curator, where I was conducting historical research about the court. The Curator's office also maintains the archives, and I would give the tours, the public lectures, as well as private tours for guests of the justices. I have a PowerPoint I would like to share. I can't quite share my screen yet until this Florida Talks screen comes down. Oh, there we go. Okay, hold on just one moment. Can you see my screen?
It's just coming on.
Okay.
Not quite yet. I'll let you know.
How about now?
Not yet.
There
we go.
All right, let me try again.
Okay.
Can you see it now?
No. When we did the practice session, it did take a few seconds for it to come on. Thanks for your patience, everyone. Okay.
Yes. Okay. Okay. Well, again, good afternoon, and I'm delighted to share a little bit about the Supreme Court and how it works. We'll take a little bit of a behind the scenes tour, and then we'll have some great time for questions. So here is the west front of the court. As you approach the building, it says equal justice under law. When you go up those grand staircase, you see equal justice under law, and you go through those bronze gates, which have famous lawgivers throughout history. There's actually a mirror image of the court at the rear, which is what you see here. And this east front says, Justice, the Guardian of Liberty. The building you can see there next to it is actually the Jefferson building of the Library of Congress. which you can also see a nice tour of that online. And from the vantage point of where this picture was taken is actually the Florida House. And so if you visit Washington, D.C., you can stop by the Florida House and get some fresh squeezed orange juice and have a little bit of home. Underneath the court is actually a parking garage for the justices and officers of the court. When you go up the staircase through the brass gates, then you're here, which is the Great Hall. And down this Great Hall are the busts of the first 16 Chief Justices who've sat on the bench. Chief Justice Roberts is the 17th Chief Justice. So here are a few of the busts, is Chief Justice Rehnquist and Warren. So there is, excuse me, only one courtroom in the building, and that is where the oral arguments are held. Sorry for my drawing here, but just to give you a sense. So the term of the court begins each year on the first Monday in October and continues through June or July. I have this is actually next term's calendar. But oral arguments are held from October through April, usually 2 weeks out of the month. Each case is typically scheduled for an hour each, with each side having 30 minutes allocated to it. So on average, 4 cases are argued a day, 2 in the morning from 10 to 12. There's a break for lunch, and 2 in the afternoon from 1 to 3. So for example, in my sketch here, you can see there's the lectern where the attorney will stand, and then these 4 tables. So the attorneys for the first case sit in the first 2 tables, and the attorneys for the second case sit in the second 2 tables. So as soon as the first case is over, those first attorneys will leave, and the attorneys for the second case move forward. So there's no time wasted between cases. It is up to the discretion of the court how long. So there are some cases that have been allocated more than that 1 hour, but typically they get an hour for each case. Usually folks will ask me, well, why only an hour? If this is, the most important issues that are facing our country and the judicial branch, why would they only get an hour? But you do need to keep in mind that before the case gets here for the oral argument, the justices have read all the previous court opinions, the briefs filed in the case, as well as many amicus curiae briefs, friend of the court briefs as well. So they're fully briefed on the arguments that each side is making. So the oral argument is really for a question and answer session for the justices to ask the attorneys questions, not for the attorneys to make big speeches. So it is very intense, a lot of pressure. I mean, there have been attorneys who have fainted during this session. And you can listen now to oral arguments online via the Supreme Court's website and also the OEA website as well. So typically about 85 to 95 cases are heard during oral argument each term, although recently during the 2019 term, only 53 cases were heard, which is actually a record low. That was actually the lowest since the Civil War when there were 41 cases. But about 7,000 to 8,000 cases are petitioned for certiorari each term, and they'll hear generally about 85 to 95 each term. Now there is a public, hold on a minute. Not during the pandemic, there's public seating in the courtroom, which is comes on a first come, first served basis. About 200 to 250 people can be seated there. And there's also actually, there's also a 3 to 5 minute line. So let's say you get there and all the seats are taken. There's actually, and that's what you're looking at right here behind the columns, is this 3 to 5 minute line. So you could still actually get in to see the case, and that's a continuously rotating line every 3 to 5 minutes, which sounds like it'd be distracting, but actually when you're sitting there, you don't even realize this is happening behind you. And that gives people the opportunity to hear a case. The very first time I went to an oral argument, I was a student and it was an abortion case. And as you might imagine, those are the most well-attended cases. So usually the quote unquote big case, they'll put at 10 o'clock and there would be a line, all the way around the court building. And that year we got there in the middle of the night and we camped out and our group was actually the last group to get in. But one of my professor's friends was one of the attorneys in the case. And anyway, it was exciting to be there. But if you were in Washington and you just wanted to see the justices and experience being in the courtroom and it really matter which case, I would suggest you go to the afternoon session where you'll have much easier chance to get in. Now, okay, so I had this calendar up. So on the calendar, you can see the argument days and also the non-argument days and conference days. So every week, the justices will meet in private conference. They meet on Wednesday after they leave the bench to talk about the cases they heard on Monday, and then they meet again on Friday to talk about the cases they heard on Tuesday and Wednesday, as well as to talk about what cases they're going to hear in the future. When the justices meet in that private conference, which I'm going to show you that conference room in a minute, they're completely confidential. No one else is present in the conference room, not law clerks, not secretarial staff, just the justices. And they will take a preliminary vote on the cases that they heard. And then if the Chief Justice is in the majority, he'll either write the opinion himself or assign to another member of the majority. If he's not in the majority, then whoever is the most senior justice in the majority will either decide to write the opinion him or herself or assign it to another member of the majority. And by senior justice, we're talking about the length of time that they've served on the court, not how old they are. The preparation of opinions is usually a lengthy process with a lot of writing, rewriting, editing. Drafts are circulated among all the chambers, not just the justices who voted a particular way. And then there is a very lengthy process, as I said, a lot of bargaining and circulating and recirculating. So, a justice that voted in the majority might say, well, if I knew this is what I was voting for, I might vote the other way. Or someone who voted the other way might be persuaded, oh, well, this seems to make sense and I'll join that. Or they might say, well, I would join this if you said X, or I would join it if you took out Y. We can talk later about this leaked opinion. That was rather shocking for a number of reasons, but it's just unheard of. But I also caution you to think that was actually a draft from February. So there's a lot that's gone on between February and May, I can assure you. And that's why for those of you who are interested in watching the court, a lot of the anticipated decisions are coming down in June because they've taken months and months to be drafted and writing and rewriting and to get a consensus before the decision is announced. So there's going to be a majority opinion, would be an opinion that 5 justices sign on to. That would be the law of the land precedent. Some justices might write concurring opinions. That is, they voted with a majority, but for different reasons. So they're writing separately, and justices could also write dissenting opinions. If they are disagreeing with what the court is deciding that day. Why might a justice bother writing a dissenting opinion if he or she lost in this case? Well, sometimes, justices are writing because they feel the need to speak perhaps to future generation. Justice Harlan's dissent in the Plessy versus Ferguson case, for example, comes to mind as a very famous dissent that might fall into that category, where he was dissenting from this idea of separate but equal, which was eventually vindicated by the court in the Brown versus Board of Education decision. Sometimes dissents give suggestions for legislative action that could correct, what the court was deciding. So in the very early days, for example, the case Chisholm versus Georgia, Justice Iredell's dissent suggested what later became the adoption of the 11th Amendment, which overturned the court's decision in that case. So, so sometimes, there might be suggestions of ways to reform legislation, which is what happened in the Furman and v. George and Gregg v. George, the death penalty cases. But regardless of however many other opinions are drafted and submitted, it's the majority opinion that's the law of the land. That's what becomes binding on lower courts. And when the decision is ready, it'll be announced in court, and then it'll be immediately available down in the public information office. There will be what they call slip opinions that are handed out on that day. But let's talk a little bit about the justices themselves. So we have 9 justices on the court. The number of justices is actually not specified in Article 3 of the Constitution. It's actually up to Congress to decide the size of the court. So the very first court, per the Judiciary Act of 1789, was made up of 6 justices, and the size changed several times throughout history. This is actually one of my favorite political cartoons. This is the Herb Block cartoon that came out around the time of President Roosevelt's so-called court packing plan. But in any case, so the number of times the size of the court has changed a number of times throughout history, mostly related to, so each justice is responsible for a circuit. Well, back in the early days, so just to be brief, so Article 3 provides for the Supreme Court of the United States. Under the Articles of Confederation, there was no judicial branch, and the framers of the Constitution were all in agreement that there needed to be a Supreme Court that would decide questions of federal law and the federal Constitution and not leave those decisions up to the states, which is what it was during the Articles of Confederation. But there was not actually agreement over a federal judicial system. And there were certainly people who were concerned about having federal courts in the states, that if there were federal courts physically in the states, that they might be interfering with state laws. So Article 3 says there would be one Supreme Court, and other courts that Congress may from time to time ordain and establish. And one of the very first things Congress did was pass this Judiciary Act of 1789, which did flesh out the federal court system and created a federal district court. So every state has at least one federal district court, but there weren't intermediate appellate courts. So that's where the circuit riding came in. So the intermediate appellate courts were made up of Supreme Court justices and then district court judges, and that was the intermediate appellate process before coming to the U.S. Supreme Court. So each justice back in the early days was responsible for riding circuits. And one of the justifications for that was that this would be a great way for people out there like you and me to learn more about the federal Constitution when, Supreme Court justices were hanging out at the taverns with us and talking about federal case law and the Constitution. And actually, I've read some of the letters that justices wrote home, and they had a lot of interesting experiences, shall we say, out on the road. If you can imagine the late 1700s, early 1800s, it's not like they were racking up frequent flyer miles or getting the warm chocolate chip cookies at the Doubletree Hotel. So it's pretty, describing like boarding houses and staying in the same beds with some of these folks out there. But in any case, why the court changed size was as the country got bigger and bigger and new circuits needed to be added, there needed to be new justices to be responsible for those circuits. But of course, as you might imagine, the timing of when a justice might be added to the court would give some presidents the opportunity to make an appointment or not make an appointment. And always, when you look at each of those times that the size changed, it did change the majority of the court at the time. So, but now we have 9 justices. The 9 justices are appointed with the advice and consent of the Senate. They're appointed for a term of good behavior, which has been interpreted to mean life tenure, and they can only be removed through the impeachment process, although none of the justices has ever been impeached. So we've had 115 justices. Justice Jackson, when she takes her place, will be the 116th justice and also the first justice from Florida. But the justices sit on the bench, in order of seniority. And the Chief Justice sits directly in the middle beneath the clock, which is that circle. And I'll show you in a minute. So the Chief Justice sits in the center, and the most senior sits to his right, the next most senior to his left, and then it alternates back and forth so that the most recently appointed justice is on the far right there next to the marshal. So the Chief Justice is considered primus inter pares, the first among equals. The Chief has the same vote in determining cases as other justices, but the Chief does bear certain administrative responsibility for the court and is the head of the judicial branch. As I said, Justice Roberts is the 17th Chief Justice. He replaced Chief Justice Rehnquist, for whom he once served as a law clerk. He was appointed by President George W. Bush and took his seat just before the October 2005 term began. Earlier in his career, he was a member of the Reagan White House. He was in the Office of the Solicitor General. He actually argued 39 cases before the Supreme Court and won 25 and was considered a lawyer's lawyer. As I said, the most senior justice sits to the right of the Chief. So currently that is Justice Clarence Thomas. He was appointed by President H.W. Bush in 1991. He had replaced Justice Thurgood Marshall, who was the first African-American justice. He was leader of the NAACP, argued the Brown versus Board of Education case. He was appointed to the Supreme Court by President Johnson. So then we go over onto the other side of Justice Roberts is Justice Breyer, Stephen Breyer. He was appointed by President Clinton in 1994. He has announced, as you know, his retirement at the end of this term. He had been a Harvard Law professor. He was an appeals court judge before, as I said, being appointed by President Clinton in 1994. And over to the left, next to Justice Thomas, is Justice Alito, Samuel Alito. He's appointed by President George W. Bush in 2006. He was also in the Reagan Justice Department. He was Assistant Solicitor General, Deputy Assistant Attorney General. He later was U.S. Attorney in New Jersey, and he was on the Court of Appeals for the Third Circuit before he was appointed to the U.S. Supreme Court. Then over to the right, next to Justice Breyer, is Justice Sonia Sotomayor. She was appointed by President Obama in 2009. She's the first Hispanic justice. She also came to the U.S. Supreme Court from the U.S. Court of Appeals. And then on the left side again, next to Justice Alito, Justice Elena Kagan. She was appointed by President Obama in 2010. She had been a law clerk for Justice Thurgood Marshall. She was Dean of Harvard Law School. She was in the Clinton White House as Associate Counsel. And later she was President Obama's Solicitor General. The Solicitor General is the number 3 person in the Justice Department, responsible for arguing cases about before the U.S. Supreme Court on behalf of the United States government. So very frequent participant in the court proceedings. And then to the right of Justice Sonia Sotomayor is Justice Gorsuch. He was appointed by President Trump in 2017. In February 2016, Justice Scalia had passed away. That's when President Obama nominated Judge Garland, but the Senate didn't act on that nomination, so it was vacant for about a year. or more than a year. And then when President Trump came into office, he nominated Justice Gorsuch, who also had been a law clerk earlier in his career for Justice White and Justice Kennedy. He was in the Bush administration Justice Department and was a circuit judge before being appointed to the court. And at the time, a lot of people asked me, well, what happens if there's only 8 justices and not 9? What happens if there's a tie? And what would happen is whatever was at the lower court would stand. So if it was the Florida Supreme Court or Circuit Court, because you need 5 justices to be a majority to have binding precedent. Then on the far left, next to the clerk, is Justice Kavanaugh. He was appointed by President Trump in 2010. He was also a law clerk earlier in his career. He clerked for Justice Kennedy. He was also an attorney in the Solicitor General's office. He was in the Bush White House, and he was a judge on the DC Circuit before being nominated to the court. And then lastly, on the far right is Justice Coney Barrett, who replaced Justice Ruth Bader Ginsburg, who passed away in late September of 2020. And President Trump replaced her just before the 2020 election. Justice Coney Barrett was a law clerk for Justice Scalia. And she was a law professor at Notre Dame and later on the circuit court in the 7th Circuit before taking her position on the bench. So that is the justices. So just a few other things about the courtroom before we move our way through the rest of the court building. So on the left of the bench is where the clerk sits. The clerk is responsible for all the legal paperwork that comes, all those briefs that I mentioned go through the clerk's office. The clerk also swears in new members of the Supreme Court bar. So in order to argue a case before the court, you do have to be a member of the bar. To be a member of the Supreme Court bar, you have to be a member of your state's highest bar for at least 3 years, be sponsored by 2 current bar members, and then there's a fee. And then if you accomplish that, you can argue a case here. Although I already mentioned how few cases come to the court every year. And of those, if the federal government is a party, then the Solicitor General is arguing that case. So you may not have a chance to actually argue a case, but you can be right there sitting in the front. And then later I'm going to show you the library. You could use the library at the court. The marshals on the far right, the marshal maintains order in the courtroom as well as responsible for the court building. So for example, the Supreme Court has its own police force and the marshal's in charge of that. Now you see the lectern there, those circles with the flashy things are the lights. So I mentioned that each party gets 30 minutes typically. So there's a white light and a red light on the lectern. And when the white light comes on, that tells the lawyer that she's got 5 minutes left and it's time to wrap things up. And when the red light comes on, the attorney is supposed to stop speaking. Chief Justice Hughes was reportedly would cut off a lawyer in the middle of the word if. So I think Chief Justice Roberts might let you finish your sentence, but that's it when the red light comes on. And then there's benches on either side of the courtroom. Again, I'll go back to the pictures in a minute, but on the far left here, you see the press. So that's the only place where members of the press can be seated. There's no cameras in the courtroom. So maybe if you've seen news coverage about a court case or an oral argument, you'll notice it's a sketch, a courtroom drawing. And you'll notice now that they're always from like the right side of their justice's face. And that's because the only place the press can sit is here on the far right. So that's the only perspective that they have. Then on the right side, there's benches for special guests, maybe spouse, maybe I've seen members of Congress there. Anyway, guests of the justices can be seated in those benches. Then in between the columns, you'll see chairs for the law clerks. Every justice can have up to 4 law clerks to help him or her with all the paperwork and helping to draft opinions. As I said, there's about 7,000 to 8,000 cases that are petitioned every year. And most justices participate in something called a Cert Pool, as in pooling their resources. So one clerk from one chambers will read through that cert petition and write a memo. summarizing what the case is about, and making a recommendation whether the court should hear the case or not. Justices Alito and Gorsuch don't participate in that pool, but the others do. So since 1925, the court has been able to pick and choose which of those cases they're going to hear through that writ of certiorari process. And it's the Chief Justice, I said earlier, he's considered the primus inter pares, first among equals, but does have some responsibilities that give him power. One of which is that it's the chief who puts together a discuss list and a dead list. And those lists come to the justices before their conferences. So as it sounds, case on the discuss list are ones that the justice thinks they should talk about, whether they should hear or not. And the dead list are cases that the chief is suggesting that they don't hear, and they don't have time to talk about 8,000 cases. So most of them get attached on this dead list. Now, if you
We may have lost your audio.
in Florida, you can write a memo to the chief and say, I think that we should hear this McLauchlan versus Florida, and no problem, it gets put on the memo. But it does give the chief some power in terms of agenda setting, and it's up to you to notice this case. And so how do you get to be from the discuss list to actually on the docket? That is through the rule of 4. So 4 justices need to vote to put a case on the docket, and then it will be heard for review. And I'd like to talk a little bit more about deciding to decide and how cases get to be from the discuss list to be on the docket. But I'm going to come back to that in a minute, because I want to make sure that we have plenty of time for questions as well later. So now let's go back to the courtroom. Okay, so here's the bench. You can see it's a little bit rounded now. That was one of Chief Justice Berger's modifications, so that the justices could actually see each other as well as the attorneys. And if you listen to oral arguments, sometimes you'll hear the justices kind of engaged in a discussion with each other, and the lawyers trying to get in a word in edgewise. Okay, so here's kind of a bigger view. You can see those benches on either side. I mentioned the chairs for the law clerks and for the members of the bar and the general public, and where the justices are. And you see that clock. That's where the Chief Justice sits underneath that clock. But if you can see this artwork, there's also what is called friezes. And these friezes on either side of the courtroom depict famous lawgivers throughout history. And then this one that we're looking at in the, I guess, above the justices, that represents that the lawyers should be representing the rights of the people. And then there's one that the justices can see that represents the eternal struggle between good and evil, and that's supposed to remind the justices to pick the good side. Here you can see the white light and the red light. So here's the lectern. Here's the friezes up close, the models that were being used. Okay, now we're leaving the courtroom. So if you were going down the Great Hall and you look straight ahead of the courtroom, off to the left, there are conference rooms, the East Conference Room and the West Conference Room, that are used as multi-purpose rooms for meetings of the Judicial Conference, social gatherings. Sometimes there's like social studies, teacher trainings in the summer, things like that. The walls are hand-carved American white oak with gold leaf, and the chandeliers were made of Czechoslovakian crystal. But the thing I wanted to take you through a quick trip through these conference rooms was because the portraits of the first 16 Chief Justices who have sat on the bench are displayed here, and I thought I could tell you a little bit about each. This is the very first Chief Justice, John Jay. He was appointed by President Washington He was one of the authors of the Federalist Papers. Now, while serving on the court, he was actually elected to be governor of New York, and he resigned from the Supreme Court because at the time it was much more prestigious to be governor of New York than it was to be on the Supreme Court. And also he disliked the circuit riding that we talked about earlier, which, by the way, the justices, all that travel, they would be away from their family for months at a time. And all of that travel was actually at their own expense. So it was a big sacrifice, actually, to be on the court at the time. Now, so he left. Oh, so people also will ask me about these red robes, and you'll see a number of the early justices on the court had these black and red robes, which was customary at the time. I was giving a paper at a conference in Dublin and got to tour the King's Inn in Dublin, which is where all the lawyers are trained in Ireland. And I noticed as well, justices of the similar time period were also wearing these red robes, as they were also a colony like we were. Okay, so after Jay left to be governor, there was a recess appointment filled by President Washington, and he appointed Rutledge to serve as Chief Justice while the Senate was in recess. Now, just because the Senate is in recess doesn't mean that you get a pass, you, the president, get a pass on having the Senate confirm your nominee. It just means that the person could serve temporarily. So when the Senate came back, they actually refused to confirm Rutledge, mostly because of his opposition to the Jay Treaty. He had said, this was Rutledge, that he'd rather see Washington dead than see him sign the Jay Treaty. I mean, it's pretty explosive comments. And so anyway, when we talk about kind of the current situation of the Supreme Court nominees and why they're selected, and anyway, you can go all the way back to 1795 to see a justice rejected because of political views. So after that, President Washington nominated Ellsworth, Oliver Ellsworth. He had served in numerous positions, including he was in the Continental Congress, he was in the US Senate, and he was actually leader of the Senate Judiciary Committee that wrote that Judiciary Act of 1789, which, as I said, basically set up the federal court system. Then we get to Chief Justice John Marshall. Now, usually when I ask like my students, I'm like, who's the first Chief Justice? Everyone also says always says John Marshall, because that's the first Chief Justice that anyone remembers. I don't remember that there's three Chief Justices before that. But Chief Justice Marshall was appointed by President Adams, and he authored the Marbury versus Madison decision that explained why the court had the power of judicial review. This portrait was painted by Rembrandt Peale in what's called the porthole motif, reserved for the most prominent citizens. Only Presidents Washington and Jefferson are also portrayed this way. So here's a little kind of a distance shot, and here's a picture of the chandelier. So Marshall's followed by Chief Justice Tawney, Roger Brick Tawney, who was appointed by President Jackson. He was author of the Dred Scott decision, considered the final straw leading to the Civil War. And so you can see he's kind of somber looking here. He was followed by Chief Justice Chase, Salmon P. Chase, who was appointed by President Lincoln. He was Secretary of the Treasury before serving on the court. And he's actually the only judge or justice to be depicted on US currency. He is on the $10,000 bill. Most likely because of his position in the Treasury, obviously not because he's justice. And this is Chief Justice Waite. He was appointed by President Grant. And he was actually President Grant's third choice. And you'll see there's a portrait within this portrait, and that is President Grant. And apparently Waite was so grateful that he had the opportunity to be on the Supreme Court that he wanted to have President Grant's picture in his picture as well. And lastly, in this East Conference room is Chief Justice Fuller. He was appointed by President Cleveland, and he instituted something called or known as the judicial handshake, which is prior to conference and prior to court sessions, each justice shakes the hand with each other justice. And that is to symbolize that although they might have differences of an opinion, that they are all united in upholding the Constitution. Now, across the hall is the West Conference Room, which, so the East Conference Room had the red carpet and upholstery and drapes, and then the West Conference Room is blue upholstery and drapes and rug, and also the more modern Chief Justices. So we start with Chief Justice White. He was appointed by President Taft. He was formerly an Associate Justice. When appointing White, Taft reportedly said, "I really wish I was appointing myself," because that is the job that he really wanted. I mean, he ended up being president, but he wanted to be on the Supreme Court. And okay, here you can see some of the ceiling and the chandelier. And lo and behold, the very next Chief Justice was Chief Justice Taft. He was appointed by President Harding 8 years after he left the White House. The only person to serve as both President and Chief Justice. Now, he is actually responsible for the Supreme Court building. So even though the Supreme Court is the head of the third branch of government, it didn't have its own home until the Supreme Court building that I'm going to take you around was erected in 1935. So the Supreme Court first met in the Royal Exchange Building in New York, and then moved with the capital to Philadelphia, and then moved with the capital to Washington, D.C. in 1800. But in 1800, Congress did not appropriate any funds for Supreme Court building. Sorry, I have to go backwards. Here we go. So the court actually met in the basement of the Capitol. And then when the Senate moved to where the Senate is now, then the Supreme Court moved up to the old Senate chambers. And that temporary arrangement lasted from 1800 to 1935. And as I said, President Taft lobbied the funds to build the Supreme Court. So this picture here shows you, if you go to the US Capitol now, you can see a space that was created for the court and now restored to look like when the court met in the basement. And then this is the old Senate chamber. So now the old Senate chamber is restored to look like it was when it was the old Senate chamber. So when the Capitol was doing this restoration, obviously then they took out everything related to the US Supreme Court. And so now there's actually part of the bench. So this was the bench when the court was meeting in this room. And they said to the court, do you want a piece of this bench? So that's now on display there. Okay, so go back to, so Chief Justice Taft left quite a legacy in the building. There he is there. But sadly, he did not live to see the building completed. So the first Chief Justice to preside in this new Supreme Court building was Chief Justice Hughes, Charles Evans Hughes. He was appointed by President Hoover. Now, he had actually been on the court as an Associate Justice, but he resigned to run for president in 1916 against Woodrow Wilson. And as you know, he lost, or else Chief Justice Taft would not be the only person to have been president and Chief Justice. Anyway, he thought the building was too ornate and very fancy. As I said, he met when the Supreme Court was over in the Capitol. So there he is, Charles Evans Hughes. He was succeeded by Chief Justice Stone, Harlan Fiske Stone, who was appointed by President Franklin Roosevelt. And he's actually the only justice to have sat in every seat on the bench. I showed you earlier how the justices sit on order of seniority. So enough justices either retired or died while in office and were replaced, that he moved all the way up and was appointed to be Chief Justice. And he was succeeded by Chief Justice, on the left here is Chief Justice Vinson, and next to him is Chief Justice Warren. Chief Justice Vinson was appointed by President Truman. One of his law clerks was the first law clerk later to serve on the bench. That was Byron White. Since then, Justices Rehnquist, Stevens, Breyer, Roberts, Kavanaugh, Coney, Barrett, Justice Jackson actually will be the 10th when she takes her place on the court, will be the 10th justice who had been a law clerk earlier in her career. And then to the right is Chief Justice Warren, Earl Warren, who was appointed by President Eisenhower. He was Chief Justice during the Civil Rights Movement. He also headed the commission that investigated the assassination of President Kennedy. Before he was on the court, he was the Republican governor of California. Before that, he was the Republican Attorney General of California. And as I said, it was appointed by President Eisenhower. Although President Eisenhower, he appointed Warren and Justice Brannon, who was both of them became well known for their more liberal rulings. And Eisenhower later said that those were the two biggest mistakes that he made. It was making those appointments. So the justices don't always maybe rule in the way the appointing president might expect, although most of the time they do. So this is Chief Justice Berger. He was appointed by President Nixon. He was he's actually the one who streamlined Supreme Court oral arguments to the 30 minutes per side. He was the one who redesigned the bench to be kind of curved. He also had the idea for developing the Supreme Court Historical Society, as well as the curator's office, which was the office where I worked, because he felt like the Supreme Court needed to have an archives, needed to have, an office that's maintaining the court's history. And lastly, this is Chief Justice Rehnquist. He was appointed to the court as an associate justice by President Nixon in 1972, and then was elevated to Chief Justice by President Reagan in 1986. So as you can tell from this really quick review of the first 16 Chief Justices that we've had, the position of Chief Justice, well, actually, the position is actually not mentioned in Article 3. We only know we have a Chief Justice because the Chief Justice presides over impeachment trials in the Senate. Otherwise, the role is not mentioned in Article 3. But the position is basically one of the 9 spots. So the president gets to select who's going to be the chief. So the president could decide there's someone who's an associate justice that he wants to elevate to be chief. So that's what President Reagan did in 1986. He thought Chief Justice Rehnquist would make a good chief. So he elevated Chief Justice Rehnquist, and then he had an associate justice spot to fill, and he filled that with Justice Scalia. So in a way, then you can kind of make 2 appointments. But as you can tell, the chiefs have come from a variety of backgrounds over time, and aren't necessarily, promoted from within. So here's a picture of Justice Kennedy speaking with a group in the conference room. Now this here is the justices' conference room. I said they have deliberations every week that are secret and no one else is present. Now the justices do take notes, and later those become part of their papers, and then researchers can review those papers and try to reconstruct what happened after the fact, long after the fact actually, but at the time, that's why this current situation is so unique. But so, and each of the justices have their own chambers. So this is Justice Breyer and his chambers, and Justice Thomas with his law clerks, the late Justice Ginsburg. So the building is like a big square, and then there are these 4 courtyards. There's Justice Kagan. There we go. Now there's actually, this room here is called the Justices' Dining Room. And if you look, you'll, if you could count, you'd see there are 9 chairs. But as you might imagine, it is infrequent that 9 justices would sit here and eat together. But for special occasions, maybe someone's birthday, maybe a spouse's luncheon, something like that, it's used. It is furnished with period antiques so that it's, kind of on par with the White House and the Capitol. the diplomatic reception rooms at the State Department. But these antiques were purchased actually by the Supreme Court Historical Society, not with not with taxpayer funding. So anyway, this room is used infrequently, but this is a dining room off that main dining room, and it's called the John Marshall dining room. And here, this is used much more frequently, maybe a couple of justices together, or maybe a justice who's meeting someone over lunch can use this. And this is called the John Marshall dining room. And when I came, so before I was hired for the court, after my interview, they took me on a private tour, like I'm giving you now. And here we are in the John Marshall dining room, and I'm seeing these portraits, and I recognize the portrait to the right as James Madison. And I said, who's this other guy? And it's William Marbury. I was like, oh, Marbury versus Madison, the John Marshall dining room. I get it. Now, at the time, I was teaching constitutional law, and of course, we spent a lot of time on Marbury versus Madison and the power to judicial review. But that case always begs the question of whatever happened with William Marbury, because the court basically said they didn't have the power to force Jefferson to hand over the commission. So, of course, there's always curious students who want to know, well, what happened to William Marbury? So I asked this of who became my future boss. I was like, do you know what happened to William Marbury? And he said, it's funny you asked, because we've been doing research, and now we know he was a banker. He became a banker in Georgetown. And I was so excited that I finally knew what happened to William Marbury. Well, fast forward some time, I had been a Fulbright scholar. I've had a few different Fulbright awards focused on rule of law and civil society, justice sector reform, including in Moldova. And I was in Georgetown, and I saw the Ukrainian embassy and went over and noticed that the Ukrainian embassy is actually William Marbury's house. And if you search the Ukrainian embassy in Washington, D.C. on their website, they have a whole section about Marbury and the Marbury house. So I would love to get to see it sometime, but I think obviously in current situation, they're not having visitors. This is the library. And again, if you're a member of the Supreme Court Bar, you could do research here. Here's another picture. I was excited to see my book on amicus briefs on the shelf. I actually tried to find out how many times justices have checked it out, but they don't have a little stamp in the back. Here's the elevator. So there's actually still staff, like an elevator operator, which might seem kind of antiquated or old-timey, but the reason for that actually is the elevator that goes from the ground floor up to the third floor where the elevator is. On the second floor are the justices' chambers. So the members of the public could go from the courtroom down to the ground floor where the restaurant and the gift shop is, but they should not be getting off in the justices' chambers. So there's someone staffing the elevator to make sure that doesn't happen. Now, actually above the library is the basketball court. So Justice White, also known as Whizzer White, he had been a professional football player earlier in his career, used to play basketball with his law clerks there. I used to actually work out with Justice O'Connor. There's a little gym up there. But anyway, this is the highest court in the land. But there's also two of these marble elliptical staircases. They are built on the principle of the cantilever arch, where each step rests on the way to the step below it. There's also staircases like this in the Vatican, the Paris Opera House, and the Minnesota State Capitol. So when I had occasion to go to Minneapolis for a wedding, but I went to St. Paul to see the Capitol because I had to see this marble elliptical staircase, which was this. So I went back to the guy at the front desk. I was like, no, principal cantilever arch, They're like, yes, this is it. So I was like, But Cass Gilbert, who was the architect of the U.S. Supreme Court, was also the architect of the Minnesota State Capitol. So I guess that's why he was interested to put one of those marble elliptical staircases there. There's also a staircase like this, two of these on either side of that great hall that take you from the courtroom down to the ground floor. And on the ground floor, there are the portraits of all the early associate justices, and the curator's office also has exhibits there. about the court that rotate. And this also is, so this John Marshall statue, which is now kind of a focal point / meeting point there on the ground floor. This actually was over at the Capitol, which now that you know the Supreme Court met at the Capitol for 135 years, you're not going to be surprised that there was a John Marshall statue over there. But it actually stayed there even once the Supreme Court opened in 1935 for many, many years until President Reagan's inauguration. And then this statue was actually in the way of the television cameras and had to be moved. So then it got to go to the Supreme Court. So here's some of the early justices. There's Justice Brennan and Oliver Wendell Holmes and Louis Brandeis, Justice Cardozo, Justice O'Connor, Justice Scalia, and Blackmun, Douglas. So there's all like that. After Justice O'Connor stepped down from the bench, they did a nice exhibit. So the chairs are made in the carpenter's office and actually belong, they're property, government property, but usually when justice steps down, the law clerks will pitch in to buy the chair. So this is her chair and her robe. And they had a nice little display. And I noticed this was her certificate that she can practice before the United States Court of Appeals. And as I read it, I was like, wow, it's not actually her name on their certificate. I don't know if you can tell with this font here on the slideshow, but it was actually her husband's name on their certificate. So Justice O'Connor, she graduated top in her class at Stanford Law School. She graduated third in her class. She actually went to law school, graduated the same year as Chief Justice Rehnquist. But she could not get a job as an attorney. I mean, she was offered like a legal secretary position. But if you can imagine being top of your class and not being able to get a job. And actually, that's kind of what propelled her through her like public service career. And at the time that she retired, she was actually the only justice who had experience in elective office. You know, earlier on in the court's history, you know, justices had a variety of backgrounds. They might be U.S. Senator. I mentioned Chief Justice Warren was governor. They did a lot, you know, maybe Attorney General. They've done a lot of things. But then when you heard me go through the bios of the current justices, it's like a, you know, more like a European career style judiciary where they're coming from, you know, the Circuit Court of Appeals as opposed to a broader background. All right, so this was the gate leading back to my office. There's a nice cafeteria and gift shop there. So, and I'll give some resources to Deb to share with you. Let me stop sharing and turn on my video. I have not been able to check out the chat, but I am very eager to hear your questions. And thank you for your patience during the whirlwind history of the court and judicial branch and a little bit of the behind the scenes of the U.S. Supreme Court. So thank you so much. And I'm ready for your questions.
Thank you. We would like everybody to know that Judy has said that she will stay to answer some questions. There's some meaty things happening. So I'm going to start with the two questions that were in chat. The first one was, when do the justices find time to do the prep work for the cases?
That's a great question. It's very intensive work. And they do, so each justice does have the assistance of 4 law clerks who help with the legal paperwork, help with drafting opinions, help with drafting bench memos. So I mentioned the oral arguments. So the justices will each have a bench memo that kind of goes through like, this is what the case is about, this is what's going on, you know, and some questions to think about and ask the attorneys. Because of the large volume of cases that are coming to the court every term, as I said, about 7,000 to 8,000, maybe up to 10,000 petitions for certiorari. That's a lot of petitions for certiorari to review. That's why the justices have, most of them have pooled their resources because each justice doesn't really have the time to read 8,000 petitions and think about 8,000 cases in addition to prepare for oral arguments and drafting opinions, etc. So they are quite busy, and they are. So I mentioned the term being from the first Monday in October through June or July, but there is a lot of work that's continuing through the summer, getting ready for the next term, reviewing the cert petitions. And I also mentioned that each justice is responsible for a circuit. Some of the things that entails is to be responsible for like a stay. If there's a death row inmate who's asking for a stay for execution. So for example, Justice Souter, the former Justice Souter, used to like to go back to New Hampshire, kind of unwind and read and relax. But he had to get a fax machine, and he resisted that because he wanted to kind of take a break in the summer and refresh. But the court's like, no, there's no break. You have to have a fax machine in your cottage, like Walden Pond kind of thing. You have to have we had to be able to reach you, because they literally are responsible for life and death decisions. Because if they don't hear it or they decide not to grant the stay and the person is executed, then there's nothing that can be done about that. So it is quite a lot of work. And the short answer is they have the assistance of these 4 law clerks. So some have said that the court operates like 9 law firms, basically, that each have their own team of lawyers working closely with them. But great question. Thank you.
Thank you. The next question was, how often is there a unanimous decision?
Not that often. Every November, the Harvard Law Review actually puts together statistics. So if you are interested sometime, you could go to the library and check out the issues with the statistics. So I'll have to get back to you on an exact percentage of cases that are unanimous. I'll send that to Deb to put with the follow-up items. But there's actually more. There is more agreement than disagreement. I mean, I think we might focus on the 5 to 4 controversial cases, but that capture our attention maybe in the news. But there's more agreement than disagreement typically. But I'm writing that down now to get you statistics on and how that may have changed over time.
That'd be great. Thank you.
So.
And I'll take another question from chat, and then anybody, if you want to ask a question and your camera is on, you can raise your hand, or if you would like to put it in chat, do it that way. The next question is, do you find that the past 4 years of SCOTUS justices are doing more shadow docket rulings and are ruling more politically than by constitutional Fed law? It's a leading question, I understand.
Yes. I would say, well, to give a general answer, I think that, what sets the court apart from the other branches and other kinds of government agencies is the need to justify what they're doing and why, as it relates to these cases. So, it's not the case that they sit in the conference room and they vote, reverse, affirm, and then that's it. Reverse, affirm. No. Along with the reverse or the affirm comes an opinion explaining why they're doing what they're doing and basing that on the Constitution, statutes, and prior court decisions, precedents. It was actually, as a side note, it was actually that was one of Chief Justice Marshall's reforms, was instituting this opinion of the court and having the court speak as one voice. So prior to his term, the court issued seriatim opinions, like each justice wrote an opinion and then you could kind of figure out like how many votes for and against. But Chief Justice Marshall's like, no, we need the court as an institution is going to speak with this opinion of the court. And so they do base their decisions on precedent. Of course, a lot of folks are thinking about the precedent of Roe versus Wade, whether that will be overturned or not. It is very rare for precedents to be overturned. The latest figure I saw was 0.5% of all of the court's decisions from 1789 to 2020 have been overturned. So there is some consistency. Now, sometimes the court might, distinguish a precedent or ignore a precedent, has happened sometimes, but by and large, they're deciding their cases based on law and precedent. And really the only, so the Supreme Court has no enforcement mechanism. Unlike other courts, like for example, the European Court of Human Rights, like they have an enforcement mechanism. The US Supreme Court does not. So the only power they have is the power that we give them and the respect that we have that they're making their decisions based on the law and the Constitution. So if or when we start to think that they are not doing that and their legitimacy is weakened, then I think they're very aware of that. Certainly Chief Justice Roberts is aware of that and seems to be trying to do his best to make sure that the court is still seen as a branch that's making its decisions based on the law and not based on partisan political reasons. But I think all of us observing might have our own views, so I don't want to. I think I'll leave it at that.
I'll jump in with a question since I don't have another one right now. I'm just looking through the gallery to make sure nobody's raising their hand. Okay, I would like you to address the leak. And if you have any insight or maybe something that's not hitting mainstream media about how it could have happened. I think everybody's asking that question, and I'm not sure I've ever heard a reason. So I was just wondering if you might be able to address that or not.
Yeah, I mean, that is really, really shocking. I mean, it's absolutely shocking. It is unheard of. And I think this is going to have repercussions beyond this case, because that's one thing. I mean, obviously there's, justices having differences of opinion, sometimes very sharp differences of opinion. But as I mentioned with the judicial handshake, right? Like there's a sense of collegiality and, oneness of purpose, even if on the specific cases there's disagreement. I think this will have very serious reverberations in how the court works and how the court operates, which has, up until now been very friendly. Even, like Justice Scalia and Justice Ginsburg, right? They were very different, but they were famously very collegial and, shared a love of opera. And, when you saw them together, they were very chummy and friendly. And I think that the court was able to maintain that level of collegiality, even when disagreeing on opinions. So this is really, as I said, unheard of, unprecedented, and may affect how the court works in the future. Because I mentioned that months and months and months long of opinion writing process, memos that go back and forth. I could join you if you said this, or I could join you if you took out that, or I can't possibly sign on to this. I need to, I'm going to change my vote or whatever. And this goes on for months, all these memos and memos, everything, all the communication is in writing, as you might expect from 9 law firms. So is there going to be how is it going to operate if you have to fear that something that you say might be leaked? So Chief Justice Roberts says he's going to have an investigation. I don't really know how that's going to turn out or what we're going to learn or what the court is going to learn, but I am sure, I'm sure there already were like non-disclosure agreements, and, the law clerks are very, well, honestly, from a very small number of Ivy League law schools typically, and it's a very small pipeline, and very, kind of elite group. I'm sure, like it used to be, this is on another side. So I showed you a picture of the dining room. So it used to be like on argument days, Justice Blackmun would be there with his law clerks. And it used to be like there was one cafeteria, like everybody would eat there, like, and you could sit there and you could hear what the law clerks were talking about at lunch. Not that they would say anything confidential but still you could sit next to them and be there and talk to them. Actually, now there's like a separate section just for the law clerk. So you can't actually sit and listen in on what they're saying at lunch. Anyway, but that said, I mean, it's just, I guess I don't have a short answer other than to say I think it's really serious. I mean, no matter how you feel about Roe or what the precedent or should be upheld or not, I mean, it's going to do lasting damage to the court and lasting damage to the relationships among the justices. And it's still like to be determined who even did the leak. Would it be someone who was potentially on the dissenting side or someone who wants to shore up the majority? Like, we can kind of debate whose interests are better served by this leak, but really nobody's interests are served, in my opinion, because of how damaging this is going to be to the court moving forward.
Is all of their work, their opinions and their memos, are they all handwritten or are they electronic where there could be hacks involved?
My experience was they're like paper and literally, I mean, they're not handwritten, but, typed or word processed and sent around physically. I mean, maybe in recent years, because it's been a while since I personally was working there, maybe they do send things. That's a good question, whether it could have been a hack. I don't know.
Haven't heard anything, just curious.
I haven't heard anything about to that effect, but, I assume they have, like protections in that regard, but obviously there's been other organizations that have been hacked. So that's a good question.
We have a question from one of our patrons who asked what leak. So maybe you can give a quick synopsis of what has happened.
So recently a draft opinion from February from Justice Alito was released and published, and you can actually all right, hold on, I started a note of what I'm going to be sending you, Deb. I'll actually send you a link to the actual opinion, and so at first everyone was wondering, is this really an opinion of the court or did somebody just make this up? But Chief Justice Roberts did verify, like, yes, this was a draft of an opinion that was circulated. As I said, in February, and knowing what you know now, who knows what it is now? It may not be anything like that early, so people were kind of picking apart some of the things that Justice Alito was saying, but other justices might have picked that apart and already said, I can't sign on to that. You got to take this out, or you got to add this. I mean, we have no idea what it looks like now until it's actually announced. But I'll give you an article. There are a few good articles about it that also have links to the opinion, and I will share that with you. But it was a firestorm because in this draft opinion, the court was going to use that case as a vehicle to overturn Roe versus Wade. So, it was in the Griswold case that the court first declared that there was a right to privacy, or explained why there is a right to privacy inherent in our Bill of Rights and in the due process. And in the Roe versus Wade case, the court extended that right to privacy to include a woman's right to decide whether to terminate her pregnancy. That included this trimester framework, which later in the Casey opinion, which is central in this opinion, the Casey, Planned Parenthood versus Casey, which was handed down in 1992, actually took away, said we're going to uphold Roe, but they're abandoning the trimester framework, and they created a new standard called this undue burden standard. So states could regulate access to abortion as long as they did not place an undue burden in the path of a woman seeking an abortion. So the truth is, between like 1973, 1992, up until this potential decision, the court was actually upholding most of these regulations as not being an undue burden. So we were already kind of on that trajectory, and a number of justices were appointed specifically for the purpose of trying to overturn Roe versus Wade. So in some ways, it's not terribly shocking that that might have been the direction the court was heading, you know, particularly with the recent appointment of 3 justices appointed by President Trump, who, again, that was what they wanted to accomplish. But what is shocking is this like leaking of an opinion during this process, while it's still ongoing, before it's even announced, you know, because usually, as I said, researchers, like I've reviewed papers of the justices for various research projects that I've worked on, but you have access to that decades after the fact. It's not like in real time. So that's what's so shocking about this, that a draft opinion would be out there for all of us to see, and potentially, you know, so now there's been a lot of protests about it. There have been protests at the justices' homes. There's a lot of you know, beefed up security to protect the court. You know, it's all of this is kind of new, you know, we're in uncharted territory in some of this. So, but I'll put a link to that, and I need to find my other thing. What did I say? Oh, the unanimous decisions. Yep. And the percent of unanimous decisions. Okay. I thought I saw a waving hand.
Yeah, I did.
Hi.
One solution to all of this that people are talking about is adding members to the Supreme Court when they continue to be so political and do things against the will of the people. So what would that involve?
So on the one hand, it's very simple, and on the other hand, it's probably impossible. So on the one hand, as I said, it's just an act of Congress, right? The Constitution does not specify the number of justices. The number of justices has changed a number of times over history. Most recently, when President Roosevelt tried to what would have added, it would have added justices. Obviously, there's a big loggerhead at the time with the Supreme Court striking down the New Deal legislation, and Congress and the president wanting to deal with the crisis of the Great Depression, and the court saying no to all of the ideas that they had. Ultimately, the court backed down with the switch in time that saved 9, and then the, you know, sort of the reason for having this sort of dissipated. Funny enough, I actually wanted to do my dissertation research on the changing size of the court because I found it very fascinating. And my professor was like, well, you're political science, that would be history. Like it's like it hasn't changed size in the 1800s. You know, like this is, you're not a historian. It's like, okay. So the president put together a commission. Actually, I'll put in a link to that report as well. So they just issued their report back in December. And so you can read that, you know, scholars who were brought together to discuss this. I mean, my opinion, and again, this is my opinion and we could debate it, is that it wouldn't necessarily help the situation to add more justices and kind of I mean, that sort of feeds into the narrative of the court as a partisan institution, and we just put more of our partisans on, and then we would win, you know, for now. But I think the long term is we, you know, as I said, I spent a lot of time working overseas, working on efforts to strengthen rule of law and democratization and justice sector reform. And, you know, we are, I mean, one of our strengths is that we have an emphasis on rule of law and independent judiciary. And, you know, so that's one of our special things that we try to help other countries in their efforts to have an independent judiciary. So I feel like efforts to make our judiciary seem more partisan may be not helpful in the long term. At the same time, I understand the frustration, particularly what happened with the recent appointments, not acting on Judge Garland, pushing through Amy Coney Barrett with 1 week before the election. Like I get that frustration of wanting to respond to what's been a partisan, what one could say is a partisan attack on the court, and wanting to respond in kind. I'm not sure that I would come down on the side of that, but again, there's good arguments on both sides for sure. But I will send you a link when I give the follow-up items to Deb, a link to the report so you could see what was said. But the ball would be in Congress's court. So again, all you would need is a simple majority in the House and the Senate and the president to sign. Bada bing, bada boom. It would be an easy piece of legislation. At the same time, I don't really see it happening. As frustrated as we might be with the court or the recent appointments, it's probably unlikely to actually happen.
Well, it may take more than Roe versus Wade. So we'll see what they take on next.
Well, you're absolutely right. You're absolutely right. That would be, I'm just kind of sitting tight on that and thinking to myself, well, that was in February and this is in May. But that said, that has been the direction the court's been going. So it wasn't like completely out of line with what one might expect. So yeah, we'll see what happens with Roe or other precedents, and there might be a critical mass of people. We also need to see, how many people come out and vote in the 2022 midterms, and that will shape things as well. So yeah, great question.
All right, thank you, everybody. Thank you so much, Dr. Scourfield-McLauchlan.
Thank you.
I feel like I've gone back to
really enjoyed
school.
it.
Oh, I'm glad.
And I learned the basics. I have been probably embarrassed to admit to anybody that I didn't know. So I feel really, really helped by you today. Thank you. I think we may all feel that way.
Oh,
and I'm looking forward to your follow-ups for sure. And everybody,
Yes.
I'll be sending things out separately, probably. You'll get a survey, you'll get the recording of this, you'll get professors, doctors follow-ups when she's ready. So expect more information. And thank you for joining, everybody. Thank you so much.
Yes, definitely. Thank you so much. It was great to be with you all.
Bye.
Bye.